Up on the report from the Joint Committee today with three members of Parliament. Liberal MP Rob Oliphant was a co-chair of the Special Committee. Michael Cooper is a Conservative MP and a member of the committee. He and other Conservatives on this committee issued a dissenting report raising concerns about safeguards. And Peter Julian is the House Leader for the NDP. The New Democrats joined the majority in support of these recommendations, but also issued a supplementary report calling for improved palliative care as well. Thanks for being with me, gentlemen. Appreciate it.
Thank you.
Mr. Oliphant, let me start with you. We're getting into some of the details of these recommendations and a couple of key ones in just a moment. But given the Supreme Court ruling, there really never was an option of not drafting a new federal law to allow medically assisted death for Canadians. I think that's clear. But how would you describe the balance you've tried to achieve in these recommendations?
I think what it is you're right, the Supreme Court made the decision about whether or not, or if we would have it, and we had to answer some other questions about who, when, how, and where. So we had to look at those questions, and in each of those questions, you are making sure that you are preserving the right that the Supreme Court has said that Canadians have to having medically assisted dying, and ensuring that there are safeguards so that vulnerable people are protected, that no one is preyed upon, so that people are clearly making a decision and it is at the right time at the right place. And so that's what we tried to do on each of those questions, guided by an overwhelming understanding of the charter protections that are given to people for those rights. At the same time, the values that Canadians have to safeguard the vulnerable in every decision. So we have looked at that and decided that the essentially the legal question is done. There needs to be a legal framework developed, but largely we have a set of medical questions that need to be answered, and we changed the name of this to medical assistance in dying, a patient-centered approach to take the focus off the physicians and start to talk about the patient.
Okay, Mr. Cooper, why have the Conservatives on the committee objected to this report?
Well, first of all, the committee had a very short timeline and a very difficult task. And I want to say at the outset that as a member of the committee, as the co-vice chair of the committee, all members of all parties took their responsibility seriously as parliamentarians and as Canadians. The report does contain some good recommendations. Unfortunately, it also contains what myself as well as three other of my colleagues feel are glaring flaws. Two areas of particular concern is the fact that the main report recommends or contemplates opening the door to minors when the Supreme Court very clearly pronounced that physician-assisted dying be only available to competent adult persons.
Okay.
Secondly, we don't believe that there were sufficient safeguards that were recommended, particularly for persons with underlying mental health challenges. Now, there really is no group of persons that are more vulnerable than persons with mental illnesses. So.
Okay, we're going to come back to those in some detail, but as an opening, let me ask you, the members on the committee, do you believe you reflect the views of the majority or all of the members of the Conservative caucus?
I think that we reached a consensus, the four of us, and I think that our views are reflective of most Conservative MPs, and I think most Canadians in terms of some of the concerns that we have highlighted.
Okay, Mr. Julian, your party supports this report, but you wanted to also to press the government to do more in the area of palliative care. What's the NDP's view of these proposals being offered up to the government as a way to proceed on this?
Well, I think that the committee did a good job with a short timeline, and we commend the committee for its work, but it's only a very, very first step. I mean, following this, and what we've said very clearly, we need to see the government sitting down and in a very balanced and sensitive way, sitting down with the provinces, sitting down with organizations to craft the legislation that has to come forward. We'll be voting on the legislation when it comes into the House, and the NDP has already said, Tom Mulcair, our leader, has already said we'll be having a free vote on this because we understand the sensitivity of the issue. The committee is just kicking off what will be an in-depth debate that we're going to have over a very important issue. And I can tell you, Peter, there are people who are suffering unimaginable pain and suffering with chronic conditions. At the same time, I come out of the disability community. That's where I was before I was elected to Parliament, and there's concern in the disability community about how the legislation will be structured and whether it will prevent any kind of abuse. So there's a very fine balance that needs to be achieved. The report starts off that debate, and it's now the government's role to do that consultation and to bring back legislation that we can debate and discuss and vote on in the House of Commons.
Right. A lot of the heavy lifting actually begins now in terms of trying to translate all of this into a legislative framework. But Mr. Oliphant, let's deal with these two recommendations that we've raised here that present probably the most difficulty for the government and may have presented the most difficulty for members of the committee as well. Allowing those with mental illness to choose a doctor-assisted death or medical assisted dying, and allowing young people, mature minors as they're referred to in the report, under the age of 18 to also choose assisted death. Well, I should point out, after the law has been in place for 3 years for adults. Let's start with mental illness. How can you decide the competency to choose death of a person suffering from a serious mental illness?
Well, just before we get to that, I just want to correct one thing for your listeners, and that all of the Conservative senators, including my co-chair, Senator Ogilvie, voted with the majority of the committee. So the Conservative Party is divided on this.
I should have been clear, members of the Conservative House caucus, I guess.
So the senators actually, in fact, one senator felt that the report didn't go far enough to the other way. So we actually think we're kind of in a middle situation. The other thing I want to clarify, that the Supreme Court of Canada, with all due respect, in its decision did not say it was limiting its decision only to adults. What it said was it was in the case of an adult, they would apply the charter. They did not say they would not apply it to someone who is not an adult, because as we know, in a Supreme Court decision, you only look at the facts in front of you. And they were very clear to say we are not, and it was in paragraph 127, we are not pronouncing on other issues that were not before the court.
Effectively, what you're saying, you mean the law was not tested, was not challenged by a minor.
That's right. It hasn't been challenged yet, and so we want to make sure that we have a set of recommendations that could withstand what we believe could be a valid charter challenge. So we've offered some of that.
Okay, so we've started. Well, now we're on to the conversation about minors. So I'll come back to hang on, Mr. Cooper. I'll come back to the mental illness piece, but let's deal now with the minors piece since we're on it. So go ahead, Mr. Cooper. Why do you object to that recommendation?
Well, just to Rob's point, and with all due respect to Rob, who I have a lot of respect for, if you apply the logic of saying that Carter merely applies to the facts in the case, then what you're effectively saying is that Carter means nothing. And that's clearly not what Carter is about. Carter means a lot. And to that end, the Supreme Court set out very, very clear parameters. Unfortunately, the committee in its main report, in terms of some of its recommendations, did not adhere to the Carter decision. And that's why we were unable to sign off on it.
Okay, so is your objection to having legislative framework deal with the issue of minors, is it your objection because minors should not have access to medically assisted death, or we shouldn't talk about it because the court didn't talk about it?
Well, first and foremost, Carter is the law of the land, and we need to adhere to the Supreme Court decision. So that takes precedence above everything else. And I should say, by the way, that Professor Hogg, Canada's most eminent constitutional scholar, was very clear in the evidence that he gave before the committee, which was that if you're going under the age of 18, you're not following Carter.
Okay, Mr. Julian, what's your view on whether minors should have, at some point, 3 years down the road perhaps, access to this possibility of medically assisted dying?
Well, it brings us back to the issue of the legislation that becomes before the House of Commons, and we would be looking for that balance, that sensitivity of clear safeguards, along with moving forward on what clearly we've been mandated to do as a House of Commons. So as far as the report is concerned, we have signed on to it. We've offered a supplementary, strong urging for palliative care that has been underfunded in this country.
Well, by signing on to it, then you're saying that you are on side with opening this up to minors.
By signing on, what we're saying is now we're giving this to the government based on the witnesses and the testimony that was heard, the committee is passing this on to the government, but we are advising the government to proceed with sensitivity and real balance and respect. And so that means on all these issues, including the two crucial ones that you've identified, Peter, proceeding by doing the consultation that's necessary. This isn't the committee report then succeeding immediately in drafting the legislation. There's a middle step, and that's the consultations that the government has to conduct now.
Okay, let's go back to the issue of mental illness now, because that's one of the other tricky ones, Mr. Oliphant. So how do you deal with this issue of someone who has a mental illness and the issue of competency in terms of their pursuit of medical aid in dying?
We received overwhelming evidence and testimony from witnesses that we should not come up with a list of illnesses that this applies to and others that it did not apply to. So you would have to rate this cancer versus that cancer, ALS versus this. And we simply said, no, we do not list illnesses, that a physician and a patient have a conversation about that particular patient in the particular illness that they're in. And if we're not going to list one illness over another, then we don't list mental illness or psychiatric illness. We cannot stigmatize, we cannot deny rights to people. However, we recognize that capacity issues and how you determine competence is extremely sensitive to someone with an underlying mental illness or an intermittent one. And we're saying that we trust our physicians with our living and our lives. We need to trust them with their dying and their deaths. And as part of the medical practice of doctors across this country to determine competency, to determine capacity every day.
Okay, Mr. Cooper,
we'll do that.
So I'm assuming you're not okay with it being left in the hands of a doctor to decide the competency of a patient who may want to accelerate their death and may have a mental illness.
Well, we are of the view that where someone has a psychiatric illness or mental illness, then in such a case it's important that they undergo a psychiatric assessment. There was a fair bit of evidence before the committee with respect to physicians in being able to identify that someone may have a mental illness, but that's not the issue. The issue, that is an issue, but the main issue after that is determining, do they have the capacity to give their consent? Okay. And that's why, for example, the Canadian Psychiatric Association was very clear in their position in saying that where someone has a mental health challenge, there needs to be a psychiatric assessment. Unfortunately, the committee fell short in their recommendation in that regard.
All right, and Mr. Julian, final word to you on this issue of mental illness.
This opens a debate that is extremely important, I think, to every member of Parliament. We'll be hearing from our constituents as well, I've no doubt, in the coming weeks. And we just hope that the government does its job in doing that appropriate consultation and bringing back legislation that reflects those consultations, but also the committee report, and allows us to move forward. And I don't think anybody is playing politics with this. I think we all are aware of the importance and that we have to move forward with real sensitivity.
And okay, we will assume that will happen, and we'll be looking forward to the debate around this, because it continues, and the government has a tight timeline here, a decision and a framework presented to the House before June 6th. Thank you all, gentlemen, for your time tonight. I appreciate it.
Thank you.
Great to be here.
Thank you.
Well, of course, these proposals from